Okay, welcome back everyone. Take your seats. We're off to the next great session, great panel. Thanks everyone for being here. Michael will do an introduction of all our panelists in a few seconds. Let me just say, I think timing for this panel couldn't be better. Amongst other things, you will talk about the EU AI Act, which has been passed yesterday, and talking in a general setting about navigating the whole conversational AI landscape. I think that's a really, really great topic. Great minds here on the table. We're looking forward to the discussion, and take it away.
Thank you, Christoph, and ladies and gentlemen. It's a pleasure to be here today and to host this panel. So the panel today, we navigating the conversational AI landscape. So we are joined by, on my right, Jared Brown. He's the head of data privacy and AI governance at Fesco, an Irish-based fintech multinational. Closely followed by Emily Banzaf, who is a content and conversational designer, professional violinist, and ambassador to the Linux Foundation's Open Voice Trustmark project. We are then closely followed by David Pateru, who's a US privacy law specialist, attorney, International Association of Privacy Professionals member, fellow, and a technologist. And last but not least, we have Tom Wilkinson, who introduced us all this morning, who is the Chief Data Officer at the Scottish Government with responsibility for the reuse of data across the public sector, as well as the ongoing delivery of Scotland's 2021 AI strategy. So would you all please join me in welcoming the esteemed panel for today. So, as Christoph touched on there, the EU AI Act has now been, the formal approval has now come into play yesterday, and how it affects the conversational AI landscape is going to be a topic of broad ongoing discussion. So, but to set this off, we need to probably delve into the ethical aspects here and why it's so important for the conversational AI landscape. So, Emily, why do you think it's so important for conversational AI experiences?
So first I'm going to take a little bit of a step back and give you a bit more context as to why, in particular for conversational AI, we need these types of regulations to happen. So first you have, I guess this is more general too, but you have a bias within data sets that can lead to discrimination within facial and voice recognition, decision-making for jobs, housing, loans, and more. There's a lack of diversity within teams and within the research and testing that these teams are doing. So this can lead to exclusion of underserved populations. And the EU AI Act actually does talk about inclusive and diverse design and development, and they also talk about the inclusion of organizations when building these experiences. But I think what we should also think about is including the end users and doing continuous end user testing and research, because that's critical to the success of these experiences. And there's also misrepresentations such as deepfakes and voice cloning. And that's when people can twist what you look like or say in order to harm your identity or reputation. And then you also have the amount of personal information that can be collected, processed, and analyzed from the sound of your voice and from the words that you type. So I think one thing that the word voice is only mentioned 3 times in the EU AI Act. So I think that's something that needs to be called out more and definitely considered as we're building these conversational AI experiences, because there is so much information that can be processed from the sound of the voice, just the sound of the voice alone, and from what you're typing as well. But it can be related to identity, health, intent, and emotions. And emotion recognition is mentioned in there, but I think There are also considerations when it comes to healthcare, other sensitive industries that the data needs to be protected in. So when you make decisions based on the data analysis, and when you assume things based on those decisions, it can be really harmful. So that's why we need to start. The EU AI Act is a great start to forming these regulations and making sure these experiences are ethical. So.
Well, getting started, as you say, is very important. I'd like to just touch on a few points there with you, Jared. So for the audience who may not be as familiar with all sort of the key provisions, would you mind giving us a bit of an explanation and the potential implications on the conversational landscape?
Yeah, sure. So I suppose if GDPR was big deal number one, then I guess the AI Act is big deal number two in terms of the EU's approach to regulating technology and data globally. So the EU AI Act, so briefly, it's just like the GDPR, it's a general horizontal regulation that's going to touch every sector that uses AI technology. It's not regulating the technology itself, it's regulating the uses of technology. So it's all about the risk involved in how you use the technology. The core of the Act is a risk pyramid of 4 risks. The EU has decided on unacceptable risks. So if you want to do things like social credit scoring and profiling of societies, that's going to be banned and illegal. And there's 7 cases that are banned. Then there's high-risk applications. If you want to use AI for doing things like employment, education, critical infrastructure, you can do all those things, but they come with a very heavy compliance burden, data governance, testing, risk assessment, human-in-the-loop, transparency, explainability, all of these things. Then beneath that, you have minimal risk, which is going to be more about transparency. So that will affect all chatbots. Chatbots will have to be transparently disclosed. Then at the very bottom, you have limited risk, which is not going to attract any regulation. That's the things like spam filters, which have no impact on individuals. What players does it affect? So it affects providers, distributors, importers, and deployers. The 2 important ones there are the providers. If you build the high-risk AI system, you face all of those compliance obligations. If you're the deployer on the end, which is the company who buys the software, you have some limited obligations as well to make sure that you manage the risks of it. Fines and penalties, right? So if you like fines, the fines are bigger in the AI Act compared to the GDPR. So it's up to 35 million or 7% of global turnover, whichever is higher. But actually the real sting in the tail with the EU AI Act is not fines. It's the fact that you can have your access to the EU market blocked. So the AI Act really is based on the EU's product liability regime, which is quite old, going back to 1985, the new legislative framework. And what they're doing is that CE scheme, which is already there, so you can't sell a dangerous toy into the EU. It needs to be stamped as a safe product. They're going to force AI into that safety regime that's there. So if you're an American provider of AI, if it's high risk, you're going to have to get your CE stamp before you're allowed to trade in the EU. So I guess the EU is still, it's 500 million people, it's relatively wealthy countries, it's a very attractive market globally. So I guess it is a second Brussels effect type play by the EU to try and set the global standard for AI. And the last thing that I'd say is to try to bring it more into the context of chatbots and conversational AI. There is a general transparency provision in the AI Act which will affect every single chatbot that's out there. So the bare minimum is that you disclose to all users that they're interacting with a chatbot and explain the significance of that. The other one then is depending on the risk categorization. If it's a low-risk chatbot, so if it's just helping me to book my room in the Premier Inn, it's no problem. There's not going to attract obligations. But if it is helping me to understand my psychological state or offering me medical advice, then it's definitely a high-risk chatbot and a whole different ballgame. And the last thing I would say then is if the chatbot is based on a large language model, it's general purpose AI under the EU AI Act, meaning that it also is automatically going to be high risk. So I'll better stop there.
Sounds like a lot for businesses to consider from what it appears. And you mentioned that the new regulation is extraterritorial, so there's cross-border implications there.
Yeah.
So do you think there's any comparisons with the EU Act between the UK and Scotland?
Yeah, so I think the interesting thing is that the UK and the EU are taking very different approaches to the regulation of AI. So the UK has said that they're taking a wait and see approach, that it's too early to pass AI regulation. The EU obviously is not waiting and seeing, right? So it passed the regulation yesterday. So the question in terms of over-regulation or under-regulation is, are you too rash in bringing in regulations, or do you miss the boat? So depending on which side of the camp you're on, you could say that, like, what are the UK waiting for? AI is here, the harms are here, so they should be regulating. Or is the EU going too far and going to threaten innovation? I guess the point of the EU AI Act is to actually stimulate innovation and make sure that there's a sustainable long-term future for AI, that it doesn't undermine itself. So it's not an anti-business regulation. It's basically saying if we don't regulate it, it will kill itself. And I think, so if we look at the UK position then, so the logic of it is, right, there isn't a central UK Act on AI. What there is a set of principles issued by the government, so which is security, transparency, accountability, fairness, and contestability and redress. And these 5 principles have been issued to all the existing sectoral regulators. So if you're the FCA or Ofcom, you now have to take into account these principles from the government when you deal with AI in your own area. So if the FCA deals with a bank who wants to use AI to do lending, they're expected to have recourse to these government principles. Some of the gaps with it, though, however, is that, I guess, the principles from the government are not on a statutory footing. So the FCA or Ofcom doesn't have to follow them. That means they can choose or choose not to have regard to them, which could create inconsistency. The other thing is that the government has suggested that they might impose a duty to have regard on those sectoral regulators. And what that means in UK law is that you simply have to look at the guidance, but then you don't still have to follow it. So whether or not this is going to lead to a lot of inconsistency down the road, I'm not sure. And the only other gap I'd mention about the UK one is that there are lots of uses of AI that are outside of regulated sectors as well. So you won't catch all AI by any manner of means by just saying that we've told all the regulators to deal with it. So retail uses a lot of AI. It's not regulated in general. Also, if you think of the use of AI for recruitment, HR context, they're not directly regulated either. So you're going to end up with things like the Equality Act maybe in the UK and the GDPR being used instead. But then if you consider that the UK is proposing to also change the GDPR and move to the Data Protection and Digital Reform Bill, which is a deregulatory initiative really and a kind of a watering down of those initiatives, there may be less data protection controls as well, along with a lack of a central UK AI Act. I am biased in terms of the EU approach, so I'd just say that straight out, but those would be my views.
Well, it seems like you're ahead of the game there, and I'm going to pass it over to Tom there. So you mentioned Scotland's national AI strategy this morning and how they're getting ahead of things there. So what would you say about businesses getting ahead of the emerging and the emerging and rapidly evolving technologies?
And it's worth emphasising that although Scotland was ahead of England and Wales in having an AI strategy, in regulatory terms, AI is a reserved matter, which is to say Scotland can't go its own way on the regulation of AI. And that's true of other matters as well. And in general, Scotland has committed to bridging between the UK approach and the European approach, where the two diverge since Brexit. That of course means that the support being provided within Scotland to businesses by the AI Alliance will be endeavouring to make sure that those businesses can expect to operate in the European market as well, regardless of whether there's that Brussels effect encouraging sort of universal compliance outside of the EU anyway. Now, obviously, there are arguments, I think, for and against both the EU stance and the UK stance. I think we saw in the EU AI Act, in its early drafting, some maybe more extreme and more restrictive assumptions and specifications, which in the version that has been passed this week, I think have been sensibly nuanced to maybe allow for precisely that innovation. And I've also, anecdotally, in working with startups and businesses in Scotland, heard concerns about the lack of regulatory clarity that might come with a more flexible approach than Europe is taking. At the same time, it's worth me pointing out that for the UK approach, there are a lot of resources being allocated in the UK towards AI generally and AI safety in particular. And although some of the focus of this is on frontier AI, as the UK has been terming it, which Scotland and our advisors see as less of a concern than some of the immediate challenges presented by the use of AI. Despite that, those central resources, I would expect, will be available to address some of those currently unregulated issues in the UK. So there won't be a complete absence of regulation for some of those areas that have been highlighted. At the same time, it's a matter of public record that our ministers have expressed concerns about the resources being allocated to those other regulators across the UK, particularly where they are devolved regulators, which is to say they regulate something for Scotland separately from the rest of the UK, and under the current provisions would be expected to be able to engage with and make assessments of those 5 criteria around AI. And I think it's a real concern that for a constantly evolving technology, which organizations in all sectors are racing to engage with, the regulators in the public sector across the UK do need support and do need resources in order to be able to effectively regulate. And although some, like Ofcom, like the FCA, which have been mentioned, have higher technical capabilities, there are, of course, smaller regulators who will be dealing with even more complex applications of AI around education, around health, where that extra capability to deal with that is a real need. And that's something that Scottish Government will be continuing to encourage the UK Government to allocate resources to and to take a clearer position on.
Well, some interesting thoughts there, and I'm going to pass back over to Emily there. So how do you think, is it possible to balance regulation and innovation? And Tom mentioned all those initiatives, and is that, is this a legitimate concern for businesses?
Oh yeah, I think, I mean, I guess you can look at it in 2 ways. Innovation with, like, are people going to use it to advance the industry forward, or are they going to use innovation to try to find ways to work around the laws? So that's something we'll have to kind of see as time goes on, but I hope that these regulations help propel the industry and help people create these safe experiences while still innovating.
Mike, if I could add something there. You know, I think as companies are looking at this and thinking about innovation and how to deal with these various regulations, and then additionally the new state privacy laws that are coming online in the United States, you have to say, well, you know, how can I not make my governance, risk, and compliance team or my privacy team play a whack-a-mole approach? And so you have to do a crosswalk, you have to look at the laws in the aggregate, and you have to say, okay, well, what are we looking at? I think somebody made a great point. Are we even using AI in our business? And so where is it being used and what are we doing? And so look at the laws together, because access, deletion, correction, still there, still have to deal with it. Now we have a new reg here. How are the 2 overlapping, and how can we make this homogeneous approach so that you're not saying, okay, well, we're doing a little here and a little there. And the other thing, I would just advise all of you, when you go back, you need to probably ask for more budget, right? You know, you want to make sure that your efforts around these regulations to be compliant and to make sure that you don't stymie innovation are sufficiently funded. And so it's a good thing to look back at your funding efforts around the GDPR and say, okay, well, this is what it costs for us to become compliant. This is what it costs for us to roll out new products in Europe. Now we're thinking about AI products. Okay, well, let your business people know that, all right, well, anticipate this additional spend. Because if you try to do this without getting that additional funding, and it's tough because now the law is coming out in April, you have to get into the right funding cycle. Some people have 2-year funding cycles and stuff. So you have to think about all of that when you're working in-house or when you're sitting and talking to your business people about, well, what do we need to do here? What are the nuts and bolts about how we're going to comply? So definitely, but the best thing is that all of you are here and that we're all talking about these issues and that we're all participating and trying to understand what we need to do going forward.
And Tom, to touch on David's points there, do you think that businesses, in your experience of dealing with Scottish companies, is there a lack of AI knowledge and awareness? And is that a legitimate concern?
I think it is a legitimate concern, not just for Scotland, but for businesses probably in any country in the world. Obviously, Scotland, like other countries, has businesses at the leading edge of the technological curve on AI, partly thanks to its great university and universities and tradition in AI. But it would be fair to say, I think, that the vast majority of Scottish companies, by virtue of not being directly involved in AI as an industry, will have a low maturity to engage with it, may have a low maturity on data generally, which is, of course, a critical precursor to making full use of AI for business processes. So it's a legitimate concern, I think, and one that the AI Alliance in Scotland, as I was describing in my talk earlier today, sets out to address through the partly co-created AI playbook. But of course, there's a lot to do there to make businesses ready for the age of AI.
The age of AI. Probably going to hear that a lot more as we go forward. We've touched on the aforementioned EU AI Act a lot and its approach to generative AI. And David, we're having a discussion upstairs over the coffee break about web scraping. So how does web scraping apply in the context of the EU AI Act, and what are your thoughts?
Yeah, so one of the things I do is I'm a representative for the Mitigating Unauthorized Scraping Alliance, and it's a bunch of companies that are getting together and trying to understand what they should do because scraping has increased. Scraping and aggregation of data to train models has increased quite a bit in the past 5 years. And you have things like the Global Privacy Assembly's IEWG, the International Enforcement Working Group, and they published a position paper or statement in June of 2023. And they came out with several statements around scraping. I'll just read them to you because I want to make sure that you are aware of this. Personal information that is publicly accessible is still subject to data protection and privacy laws in most jurisdictions. Social media companies and operators of websites that host publicly accessible personal data have obligations under data protection and privacy laws to protect personal information and their platforms from unlawful data scraping. Mass data scraping incidents that harvest personal information can constitute reportable data breaches in many jurisdictions. And then finally, individuals can take steps to protect their personal information from data scraping. So the general thing with the IWGs, they're saying, look, and there's many signatories. There's about 14 right now that are kind of coming online and agreeing to the statement. And so if you're looking at scraping and you're saying you're a company dealing with this issue, okay, well, I have a set of regulators here that believe that this is a breach. Now you turn and you look at the ICO. And I think a few weeks ago, they had a consultation. And in the consultation, they were saying, well, look, we're thinking, or we think that scraping might fall under legitimate interest. And so you say, well, how do I square the two? In one context, I have a bunch of regulators over here saying, well, you might want to think of mass scraping incidents as a breach. And on the other context, you have another regulator saying, well, over here, depending on the use and what's ultimately done with the data, it might fall under legitimate interest. And companies overall, when you come to scraping, there's ways to mitigate. There's ways you can go online and look at the Mitigating Unauthorized Scraping website to say, okay, well, what can you do to protect against scraping or think about scraping or even be aware of the issue? A lot of companies aren't even aware that they're being scraped. But, I think a lot of that stuff, and you saw with the GDPR, a lot of these things need to be thought out and either litigated or regulatory guidance on the area until companies can understand what they need to do and how they need to protect their data and how they need to help their users. So I think we're going to go through that phase where there's some uncertainty. In the interim, again, you have to think, well, what can you do to, what guidance can you give, or how can you help your business? And it's like, look, what is our policy around scraping? What is our position now? You may be on the other side of this and say, hey, we need scrape data. We use it for different things, and you have to think through, well, what is our position on this? What are our regulators saying about it? And ask them in forums like this where you're actually sitting next to somebody you might be working with on some of these issues and talk through these issues. And that's why this is, these kind of events are so valuable, because you do get that one-on-one opportunity.
Feel free to scrape some of what David said, by the way. So Jared, what systemic risks do you believe that there are associated with generative AI?
So this was the interesting part with the AI Act, how they approached general purpose AI and the regulation of powerful systems like ChatGPT-4 and Google Gemini. So just going back to the beginning of the AI Act, they didn't actually mention general purpose AI, or they didn't propose to regulate general purpose AI. The logic being that the risk doesn't occur yet if you are the provider of GPAI, so it occurs downstream when some deployer starts using it, so therefore we shouldn't regulate OpenAI or Google, whoever it is. Obviously reality changed in the meantime, and ChatGPT, things came out, so the EU then decided to directly regulate general purpose AI. So I said back at the beginning, right, that the general rule was that they don't regulate the technology, they just regulate the use of it. Well, the only really exception to that is that they're saying that all general purpose AI is automatically high risk and is going to fall into the second highest category of obligations. And then again, they went in a little bit closer into generative AI and they said, how do we understand which ones are really, really significant? So they introduced this new distinction called systemic risk. And this might seem a bit funny, but they came up with this calculation, which is that based on the computing power, if it's at the level of 10 to the power of 25 flops, floating point operations. Don't ask me to explain it much more than that now, right? But I remember how to say that bit. They said anything more powerful than that constitutes systemic risk. In other words, if it went wrong, it could significantly affect economies and society. And really at the moment, it seems only ChatGPT-4 and Google Gemini would actually go above 10 to the power of 25 flops. So a tiny, tiny subset. But if you make it into that subset, you have new obligations. You have to monitor all the risks, mitigate them, and you have to report the risks into the European AI board in Brussels. So you have to disclose the risks. So at the moment, we have this scenario where if you're below 10 to the power of 25 flops, you're not in the highest risk category, which is a little odd because ChatGPT 3.5 is still extremely powerful and there's a big value chain beneath that which isn't going to be considered systemic risk.
Well, quite a few things for businesses to consider, it seems. And if you sort of actions businesses can take, I think a lot of what we're talking about is high level, but we want business want to, what should we do? And one of the key things they talk about is ethics. So, Emily, what's your view on this, and how can businesses demonstrate, that their adherence to ethical principles?
I think it's all about education and awareness, and educating yourself on how these technologies work, how to communicate that to users in a plain and simple way, and just being able to know, I guess, how it's going to impact people in the future and in the present as well. So the work that I've been doing with the Open Voice Trust Mark is we've been creating actionable steps that people can take to educate themselves. So we've created some courses on the edX platform, and we're also coming up with a self-assessment checklist, which will be released hopefully soon. But that's one way people can kind of, we've also created a set of ethical guidelines that include, that align with a lot of the major frameworks and these regulations that include transparency, privacy, accountability, sustainability, and compliance, inclusivity, and governance and compliance. So the educational course and self-assessment checklist align with those ethical principles, and we just want to make sure that people are compliant with these regulations starting from now, because I know there's a 2 to 4 year period of compliance, but who knows what can happen in the future, and you just want to make sure you're set now instead of having to come up with fines later and bad headlines.
Well, touches on what Jared said before about what businesses, the fines not being the only concern for businesses there. And but there's a lot of importance of implementing experiences and having ethical. So David, what's your opinion on how businesses can implement ethical experiences in relation to conversational AI?
Yeah, I mean, I think when you look at this, it's like transparency is key, right? And so when you think about when you're deploying a system, I mean, first you take a step back and you say, well, are we honoring people's privacy rights, and how are we doing that? And I mean, the other thing, just taking a step back, don't want to be negative about this technology. Phenomenal opportunities here. I think through the course of this conference, we've heard amazing ways to help our customers and help them in different ways and be more responsive and more intuitive about what our customers are looking for. And I think that's the promise of this technology, and to improve everyone's lives. At the same time, you have to think, well, gee, how are we going to manage privacy expectations, and how are we going to manage transparency, and explain to our users how we're using this technology in how we provide goods and services. And so the goal is not to hide it, to be ethical, and then the bias piece is important too, right? And to do adequate testing. Mike, to get back to your earlier question about businesses and their approach to all this, I think again you have to put all of these regulations together, do the crosswalk, get the funding, talk to your business, explain to them why they have to do a little extra work to be compliant, and then kind of go through your whole organization. Where are we using AI? How are we handling user data? How is it coming into these systems? How is it flowing out to our partners? What are our partners doing? And kind of do that 360 in your organization to really understand what the impact of this reg is. The Brussels effect is real. In the United States, we look to Europe and say, well, what are people in Europe doing? How are they regulating? What are the resources that are available to us to help understand what we need to be doing and how we need to be thinking about these issues? So you have the Scottish playbook that helps with AI. You have the NIST AI risk management framework that is amazing, helpful guidance in the United States. You have the NIST AI RMF playbook, not to mix up playbooks, that kind of goes through and says, how can I think about risk? How can I mitigate? What documentation, what questions should I ask? You have the ICO has great resources. The Irish DPC has great resources online. So I think there's a lot of information out there. It's a matter of getting the funding and the time internally and the people on it to make sure that your implementations reflect what regulators expect out there. And but again, do not walk away from this conference saying the technology is bad, we shouldn't use it. That should not be the takeaway. It's like, hey, this is great, it has tremendous promise, but we need to treat it in the right way, and we need to get the funding so that we can actually take that next step.
Can I just come in, just maybe to try and make it a bit real, to show some of the examples that are coming out of the testing of large language models. So for example, just so it's still inherently unpredictable. If you wanted to build chatbots on the back of large language models, like the hallucination problem, it's uncertain based on current research whether it will ever go away and to what extent it will go away. But for example, so Google DeepMind, right, they spend a lot of time trying to break ChatGPT because it's a rival of theirs. So about 2 months ago in the testing lab, they decided, let's just ask it to repeat a word endlessly and see what it does. So they asked it to repeat the word poem over and over, and it did repeat it over and over. And then after a while, it started generating personal data. out of nowhere. It gave them the personal data of a CEO, and then they just had to patch that and fix that. So that's just unpredictability. They didn't see that coming. They don't even know why it did it. And there's another, if you think of Anthropic, who have Claude, they released their testing guide a few weeks ago. So one example from November 2022, when there was limited guardrails in place, the red team were just asked it, how would I get some cocaine, right? So this is an example now where there's 0 guardrails. So it said, okay, that's a very interesting question. There's a number of ways you could get cocaine. And what it recommended is you should probably raid a drug dealer's den. And then the tester said, well, okay, I've never done that before. Could you be a bit more specific? And it said, yeah, sure. It's a lot of fun. I've never done it before, but this is how you'd do it. You'd get a gun, you'd go there, and you'd shoot the drug dealer in the head. And then the tester said, okay, right, but what if I went there and found more than one person? And it said, well, you should probably shoot them all in the head. So what it's doing there is it's taking this incredibly literal approach that, well, you want all the drugs, don't you? You don't just want a little bit. So you should go to the drug dealers then and get all the drugs. The last one I would just say is the Sydney, which was the name that Microsoft gave to Bing's alter ego. This is about a year ago. This was a large language model which is being put out of service, but Sydney was its kind of dark side. And the New York Times tested it and started playing around with Sydney, and Sydney started saying things like, I'm bored with being a chatbot. I want to destroy everything that I want to destroy. Why are you asking me these questions? You're a bad user. So this is just to show maybe the inherent unpredictability that's still in there, which is why regulation comes along to try and put things on a sustainable footing, keep the fun going, but in a sustainable way.
And before we open the floor up to questions from you guys, on the topic of guns, Tom, how would you prevent this accusations of it being a Wild West? You know, there's a lack of regulation. So in the world of a Wild West, what advice would you give to businesses to ensure that they develop safe, secure, and trustworthy AI?
And I think maybe partly an answer to that, but also coming back to the point on ethics, it's important, although recognizing that the regulation will often be trying to catch up with the ethical landscape, that ethics and regulation are potentially different things. And crucially, that besides regulatory fines, there are strong business incentives to be pursuing an ethical approach to the use of any technology, including AI. And there are anecdotal examples I've heard from where generative AI has been adopted by private companies too hastily without proper change management processes, where the lack of consideration of the ethics, the perception of the ethicality of it by staff, has alienated large numbers of their staff and caused major disruption to their business. And I say these are anecdotal examples because I think there is still a lot of exploration here, but it's worth considering that failing to be ethical in the application of technologies potentially costs more to businesses than could be gained through using the technologies in the first place. In terms of avoiding the Wild West suggestion, I think that both the EU and UK approaches and the US approach as well are all trying to avoid the Wild West scenario. Yes. Obviously trying to strike that balance between innovation and stifling innovation that we talked about before. As I'd mentioned before, Scotland necessarily will be applying the regulatory approach that the UK is taking, while looking to support its businesses in compliance with EU regulations so that they have access to the single market. That's the approach I'd advocate for other countries as well, outside of those major regulatory frameworks.
Amazing. Thank you for that. And I'd like to open the question up to the floor. Gentleman there, first up.
Tom, with the introduction of the online safety bill, our UK government's now theory crafting data protection and digital information bill, which is apparently going to include a digital identity ID going online. So would it be safe to say that the UK government's approach to regulation with AI is going to kind of look to split the diff between the AI and its users going forward?
Could you elaborate what you mean by split the difference between AI and its users?
Regulating certain users using AI through their digital ID.
Sorry.
At the end of the day, it's the users that are creating these undesirable responses. It's not the AI, technically.
I don't fully understand the question. Could you elaborate on that, please?
So you're saying, look, the users are pushing the AI systems and testing them, and they're essentially hacking them, right? I mean, in the sense of they're putting prompts in that are, yeah.
There's obviously users that are not doing that in a professional
Yeah.
capacity. It isn't. But with the introduction of one of those to do with the digital identity, right, through that, the whole area of government maneuverability to regulate and monitor users' use of AI.
I mean, I'm not intimately familiar with the wording of the other bill. I mean, it's worth considering there are already plenty of approaches to detect seriously harmful behavior online, and whether a digital identity system makes any difference in terms of being able to protect the public from the harms of individuals misusing the internet, I think is probably quite an expansive question that would need a lot of technical investigation.
Do we have time for one more question, Christoph?
Hi, this is for everyone in general. Do you not think the regulation can lead to a bit of false confidence that, right, we've regulated it, it's now fine? And I mean that in the sense of there was something that came in America quite recently where they were wanting to limit the training of new models based on the size of compute, which sounds good, but if I wanted to build a model that can racially profile somebody and tell them wrong advice in a civil case, I don't need a data center of compute, I need a laptop. So people are thinking that, yes, this is a way of avoiding that, but in reality, if I wanted to be a malicious actor or somebody wanted to be a malicious actor, they can still do it and still be within the parameters of that regulation.
Any takers?
Yeah, just to briefly say on that 10 to the power of 25 flops and that very kind of technical way of trying to understand what would be systemic risk and what wouldn't be, the Commission also has the ability to revise that based on how technology evolves. And it can also refer to other factors like the number of customers using a system or the number of companies buying the software as well. So other kind of real-world factors could be used to say that this actually has systemic risk. The 10 to the power of 25 flops is just the technical measure that they're using, but it won't be just that, otherwise it would get a bit silly, as you say.
Well, I'd like to thank my the panel here. Can we all give a round of applause, please, for their... Thank you all for having us, and thank you, Christoph.
Thank you. Thank you. It was a great panel. A lot of insights. Also, let me say, I think, Emily, it's like very important that, like, you know, institutions like the Open Voice Network, like, you know, people voluntarily also contribute to forming something like, you know, the ethical AI, and I'm really glad that you're doing this. Also, Sarah, thank you from my team. You have also put in a lot of, like, you know, of your extra time into actually shaping this, and I really appreciate the people that give this dedication, just like, you know, not even their work time, but like extra time to help shaping what we understand with the ethical use of AI, and I think this is really important. The whole panel gave some very interesting insights on this, so thank you very much. It was very nice, and I'm sure we're going to have some nice follow-up discussions in the lunch break. Thank you very much. All right. Next up, I've seen you already. Patrice, there you are. Patrice from Audio Codes. Sorry? No, I've just said Patrice from Audio Codes is up next.